Hello, my name is Tom Wilson. I'm on the wrong end of a $110 million lawsuit from your friends at Geranium. And I'm a very naive lawyer. But I wonder if if it were made part of the law that when somebody is making a statement of claim, that in that case Earl Rum would have to swear an affidavit that says, to the best of his knowledge and belief, the facts set out in the statement of claim are true and correct. And if it could be shown that they weren't, he'd be in contempt of court and wherever that would go. On top of that, I think if the situation called for the lawyer who's bringing the claim forward to swear an affidavit that says, also, to the best of his knowledge and belief, the facts are true and correct, but also go further and say, and further we believe that the facts support a legitimate claim of whatever the statement of claim is. Again, you've got the lawyer having, swearing an affidavit, which in our case, I'm not so sure that the lawyer could honestly swear those affidavits. Would that slow things down, or am I just being naive?
I think my lawyer left, so maybe I'll just have a quick whack at this. In our own case, in terms of the cost claim that was made against us and me personally, it was alleged that we withheld evidence that the Lake Simcoe Protection Act was only it wasn't the law at that point. And they accused us of bad faith, which if that had been found to be true, then I would be in jeopardy with my LPIC, my lawyer's insurance. But in actual fact, we had put the material in front of the board. We had actually submitted it. And they made this claim and swore an affidavit and put that material before the board, even though it was false, demonstrably false, even before they made the claim. And so I think part of that is holding the lawyers accountable when they bring these actions. They're a member of a profession, and they have a duty to get it right and not bring these cases if they think that they're meritless. In our own case, particularly the matter of bad faith, it was false on its face when it was filed, and we proved it to be true, and somebody should be held accountable for that, and that's the lawyer, not the developer.
I couldn't agree more. I've been visited by a SLAPP recently. My crime was to enter into a joint project agreement with Environment Canada and produce a report, which I disseminated. Now, in terms of the role of the lawyers, I'm really having a hard time making any kind of a distinction between them and their clients. They appear to be more business partners. Your trip to the Law Society, perhaps an internal watchdog, shall we say? Am I looking at the fox guarding the hen house for this kind of thing? I've been to many regulators under whose jurisdiction this clearly falls, and it's taking its time. But I'm curious about the Law Society and how they regulate their own members and the behavior, those that engage in this kind of activity when they should know, or they do know, that it is a SLAPP that they are bringing against an individual or a group.
I've had 2 complaints to the Law Society. One took quite a while to resolve. In the Big Bay Point case, there was a complaint against me for evading service, even though I was represented by an LPIC lawyer who was at Weir & Folds, a very large Bay Street law firm. And I have to say, credit to the Law Society, that claim was dismissed within 24 hours, and they said that it was a record for dismissing a claim. I think she was being offhanded, but it was dismissed very quickly. So in my own experience with the Law Society, they have dealt very, I think, even-handedly and in fact expeditiously with the matter. So I don't have a problem with the Law Society, except to say that I think they should take a more proactive role in investigating some of these claims and doing the back-end work, which is to say, well, you're really using the profession for an untoward end, and maybe they need to join us in looking at SLAPPS protection being part of the solution.
In Quebec, there's only 2 major big groups who actually oppose Bill 9. So one of them is the organization that represents big business interests in the province, so it's not a surprise. The other one is the Quebec Bar, actually, who furiously opposed many times and publicly the very idea of an anti-SLAPP bill in Quebec. So it's troubling me to realize that. They actually say like it's basically the same discourse that what happened in BC a few years ago. They say that there isn't as many cases that would justify the imposition of a new anti-SLAPP bill, and that the legal system works pretty fine as it is right now.